All right, my friends. I just pressed the let's go live button, which means we've got to wait for the stream to fire up all across the fruited plain of the interwebs before we go ahead and get started. Got to make sure those tubes are working. Been a couple of days since we've been back in the chair, but we made it back home from Vegas. We had an absolutely amazing Watching the Watchers meetup, and we'll have a full debrief on that most likely tomorrow. But today we've got a lot of business to attend to, and so let's get into it as soon as we can confirm we are live, and it's looking like things are pretty good. So let's go ahead and get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about some prosecutors who are in trouble. Not looking so good there for Jack Smith and Alvin Bragg. We got some big updates today because in New York, looks like Trump's sentencing has been delayed. Oh, man. Judge Merchan so unhappy about this. This all comes on the heels of the Supreme Court verdict and opinion that we read through before, where they now say that Trump has some form of presidential immunity. Now, we're going to wait for Judge Chutkan to say, no, he doesn't, because I said so. And then we'll see what the Supreme Court says about that later on. But now we're watching the domino effect, the splash zone that comes out from this immunity decision touch all of the other cases as we predicted here. But this is going to be a big one. So Trump submitted a filing to Judge Merchan and told him, we told you so. Remember, Trump has already made the argument in the New York case that the whole thing should have been stayed pending the Supreme Court decision. In other words, they said, hey, dumb judge, you better wait, because once SCOTUS comes back down, you're going to be in big trouble. And he said, no, SCOTUS isn't going to find anything that's going to impact my case. Turns out Trump was right. Judge Merchan was wrong. And so Trump submitted this saying, we told you so. So what are you going to do about it? And then we fast forward, and the government responded basically in agreement. They said, well, all right, Trump's going to need some more time to respond to this. We're going to need some more time to respond to this. And so we're okay with a postponement of the sentencing. And Judge Merchan came back out today and said, okay, granted. And there's some very interesting language in here that Merchan is admitting that we'll have a sentencing if it's necessary. So that's not so good for them, because guess what? It's not going to be necessary. And guess what? That means there's not going to be a sentencing. And if there is no sentencing, then there is no conviction. And Donald Trump is not a felon. And they're all going to have to go back and eat their own words because they're wrong. So we'll go through all this, explain what's happening. We also had this other filing from Bragg that was a little bit before these other filings, saying that when we have sentencing, by the way, we don't want any cameras in the courtroom. We don't want anybody to see it, because they want to carry all of this stuff done under the dark of night, as we'll see. So we'll go through some updates, some filings there, and then we'll see what Rachel Maddow says, because she's saying that Trump is, you know what, if he wins office, guess what? He's going to go after his political opponents. That would be shocking. That would be crazy if that happened in America. Oh no, what would we do if suddenly something like that were to happen out of nowhere? So we'll see what she says about this. They're all doing their little hyperventilation, trying to regain their credibility, trying to promise their viewers that they weren't lying to them over the last several years. But all of that is coming up in the first segment. And it's a good update. It's a good update. Judge Merchan having a pretty bad day. Then we're going to turn our attention to what happened with the Supreme Court yesterday and zoom in on the concurring opinion from Judge Clarence Thomas, because something that kind of went a little unsaid yesterday was that Clarence Thomas came out and laced into Jack Smith, said, oh yeah, you're illegal, Jack. Your appropriations, your money is also improper. And so you should not even be here. Your entire reason for existing is illegitimate. And so we'll see what Clarence Thomas said in his concurring opinion. Not a long one, but some pretty juicy stuff, because this might be a nice hint for Judge Eileen Cannon in the Florida classified documents case saying, Judge, you've got a friend up here on the Supreme Court, and it's a good friend. It's called Clarence Thomas. So we'll go through that opinion. Even MSNBC is saying that the Supreme Court immunity decision means there's not going to be a January 6th case before the election. Oh, no. And also Trump's lawyers are confirming what we said yesterday, is that this is going to touch every case, basically the RICO case in Fannyland. We've got the idea being that there's alternate electors that were communicated with, and she used that as part of her indictment. Same thing in the J6 case. And so everything that they've charged is going to be protected as an official act, which, as we recall, deserves at least a presumption of immunity. And they can't even use Trump's mindset or his mens rea, right, what's going on in his brain, as evidence. So the force field is going to be very strong. Trump's attorney is communicating accordingly. Jack Smith's in danger. The Supreme Court saying that he's got to go, at least from Clarence Thomas. And so we'll go into that all in the second segment. And then we'll zoom in on the classified documents case, because there's a lot of unsettled issues over there. We're still waiting on some rulings from Judge Cannon. We know that some other rulings didn't quite go Donald Trump's way, but you only need one motion to dismiss to be granted. And this was another one that came out today. Remember, we talked last week about the spoliation of evidence being spoiled, in particular, Trump's exculpatory evidence, which is pretty important evidence because it tends to show the defense is, innocent. We need that. And so if they wrecked all of that, that's a big problem for them. And Trump's remedy is a dismissal, a sanction that says the case has to go bye-bye because Trump cannot prepare his defense. And since he can't prepare it, the prosecution that caused that deficiency has got to go. So Trump submitted his reply on this, and they're pretty fired up on this, saying that they took the boxes, they manipulated the boxes. They keep telling us they had all these different rules, all these different standards for how they conducted their investigation, but then none of the standards were met. So we'll go through that and see what Trump's defense says. We also have an MSNBC lawyer. I've got some good clips from MSNBC. They're like, yeah, this guy says, yeah, I mean, immunity makes sense. Just stop being a demented freakazoid who hates Donald Trump, set him aside, and realize this makes logical sense in our country. Just like not throwing people off the ballots makes sense in our country. The Democrats still having a hard time understanding how a functional country should work. And then we'll wrap up the day hearing from Alina Habba in the House. We'll see what she says about all of this stuff with her brilliant legal analysis as we go through the show. And so, as you can see, my friends, we got 3 good segments today. This morning, we recorded a couple other segments during our Membos stream. We talked about Tucker Carlson. He had some banger tweets out there saying that there is an actual plot right now to remove Joe Biden. They're not going to tell you to your face about this, but they'll remove him because they have to play both sides simultaneously. We talked all about the Indiana Jones head and how right now they're not just going to pull Joe Biden's head off, okay, and then just leave it blank. So they're preparing right now. Oh, Joe Biden's great. No, this head's great. And then they're going to move it off. And then you'll see Obama and everybody else abandon ship and jump on to the new candidate. So Tucker Carlson had some tweets about that. Bill O'Reilly had some tweets about that. We recorded some segments for our Membos. We love our Membos. Thanks for being Membos. Those segments will be out later if you're not a Membo. We also talked about lefties calling for the assassination of Trump, which was wild. A UK journalist, and we saw later on in the day, there was another article from the Huffington Post, I think. I think they were kind of being jokey about it, but not really. I mean, they were also saying that, hey, now, since Trump can assassinate people, I guess Joe Biden can assassinate people. And we're all sitting here saying, did you morons even read the decision at all? Because that's not what it says. Hello. So we went through that and broke that down. What does it mean? And how does it work? We also listened to Mark Elias say, we're all going to get executed by Trump. It's just a total meltdown from them. So it was a lot of fun. And we're grateful that you were there this morning, Membos, and joining us. Now, we got some good stuff. Those segments will be out later on the main platforms. But before we jump into any of this, my friends, we got some business to attend to talking about this bird flu stuff. Have you seen this story over from the USA Today publication? Check this out. They're creating a jab for this thing. A bird flu jab is now in development. And guess who got it again? Guess who got all this government money? Moderna. Are you kidding me? Now there's a multi-state outbreak. So Moderna is going to get $176 million in federal funding to develop a human vaccine against the bird flu. The U.S. has documented 3 cases of humans in 2024. All had regular contact with dairy cows. Now you see the HHS award now awards this is going to go to developing an mRNA-based pandemic influenza vaccine. Perfect. Perfect. All right. So they did a great job of all of this last time, as we know, and we're not going to get caught up in the pandemic again like last year. And so what can we do? We can be prepared. We can have life-saving medication on hand that doesn't come from those knuckleheads like the last time and have it handy for us. It comes in a nice little kit that looks just like this. And it is a prescription contagion emergency kit from the Wellness Company, as you see right here. Now, it's the only kit of its kind, has a bunch of good stuff in there. Different medications for things like bird flu, COVID, respiratory illnesses. You'll find ivermectin, hydroxychloroquine, Z-Pak, Tamiflu, all sorts of different things in there. Along with budesonide, a nebulizer. You're going to have all the emergency medications on hand, a guidebook for how to use it. Dr. Peter McCullough, other amazing people like him, back this with their research, and every American should have at least one of these. And it's very easy to get yours. Go to www.twc.health/Robert and use code Robert to purchase your kit. You're going to save 10% off when you use code Robert, and you're going to get free shipping. And that way you'll get this. Going to come quickly. You'll be prepared no matter what. Go to twc.health/Robert. Use code Robert at checkout, and these kits are only available in the USA. And we were actually talking about this at the Wellness Meetup over the weekend, saying, what about our friends in Canada? We had to come up with a solution for that, maybe cobble it together on your own. But in the United States, you can grab this. I've got mine. And that way we have it ready to go in case we need it. All right. And so our friends at the Wellness Company. Now, without any further ado, let's get into this one, because Alvin Bragg's in big trouble. So is Judge Merchan and the rest of the Democrats. They really wanted Trump to be sentenced so that they could call him officially a felon. But that's not going to happen anytime soon. Maybe not at all. Judge Merchan is even saying that. We'll see if this even has to happen now that the Supreme Court has said Trump is entitled to at least some immunity. And Judge Merchan didn't go through that inquiry at the start of the trial. So we're going to talk about what's going on here, because Trump submitted his challenge to the conviction, saying, you done goofed here, Judge. The government responded, said, we're going to need a lot of time to investigate this. And Judge Merchan agreed. And there's some very particular language in there that's going to matter bigly. So let's go through some of the filings and see what happened before we get to the judge's official ruling. This came out right after the Supreme Court from the Trump team. Remember that this judge, Judge Merchan, who donated to Joe Biden twice and whose daughter works for Joe Biden and does fundraising for him, made $93 million for the Democrats, all the things. Trump submitted a motion to him that was asking him to consider immunity. And the judge said immunity does not apply to you. And when Trump appealed that, they also said it doesn't apply to you. Okay, so Trump has already brought this up. It was already denied. So that is etched into the record. So we can refer back to that and say, oh, remember when we asked you about that and you said no? You should have said yes. You screwed up, Judge. So now they're coming back. They say, all right, Your Honor, well, nice to see you again. We respectfully submit this pre-motion letter. And this judge doesn't want actual filings from anybody. He just wants one page. He says, write a pre-motion before you submit an actual motion, because he doesn't want Trump to muck up the public record with the truth. So he keeps all of that buried. And so as we see here before, Trump now puts margins all the way to the very end to squeeze as much as he can onto a single sheet. He's like, oh, I get one page? Okay, how about we do 0.333 margins? And for those of you who've ever tried that, you know your printer starts screaming at you, and then you say, just do it. And it says, I don't want to do it. You just do it. I can't do it. It's not going to print. Do it! And your printer starts to overheat, and eventually you guys get into an argument, but it does. It spits it out. And here it is. So Trump is now submitting this to the judge. He says, listen, Your Honor, we're submitting this pre-motion letter seeking leave. We're going to file a much fatter motion here in a minute to set aside the jury's verdicts because they're illegitimate, pursuant to New York law. And that's based on the decision today that came out from the Supreme Court. Now, as explained below, Judge Merchan, the Trump decision from the SCOTUS confirmed the defense position that we already tried to tell you. that Alvin Bragg should not have been permitted to offer evidence of trial of Trump's official acts. We done told you already, but you didn't listen. Now, we respectfully request until, and this is like a big thing, all right? There's you should not have been permitted. We told you no. You said yes. We said absolutely not. You said absolutely yes. It's on the record. There's tons of filings. We read them. And so, since you were wrong, we respectfully request until July 10th to submit a memorandum of law in support of this motion. Now, because of the complexity of the issues here presented, now we're only limited to one page, but they're saying we're going to come back with a friggin' phone book. Because of the complexity of the issues presented, President Trump does not object to an adjournment of the July 11th sentencing date, which was scheduled right around the corner, in order to allow adequate time for a full briefing, for oral arguments, and for a decision from you, Judge, because we need to get into this. So here's the background, just in case you forgot. By way of background, on March 7th, 2023, some months ago, President Trump filed a motion in limine, which is a preliminary type of motion to preclude evidence before the trial ever started, to say this cannot come in, and we have to keep out specifically official acts, and it was based on the presidential immunity doctrine. Do you know why? Oh yeah, because we were talking about that in the Judge Chutkan case in Washington, D.C., knowing that this was going up on appeal. Now, in that filing, which we told you, Judge, we objected to anticipated testimony from certain potential government witnesses, evidence of President Trump's social media posts and his public statements. None of that should have come in because it was official. And a 2018 filing with the Office of Government Ethics, all of these little bits of evidence. Witnesses might comment on official stuff. Trump's social media posts might reference official stuff. Public statements clearly official. 2018, he was the president. So we also requested an adjournment of the trial. So we told you, first of all, right, they made a bunch of requests here. And let's tease these out. But one is stop the evidence from coming in. So sure, we'll have a trial, but all of that is a force field that is protecting that information from coming in. Now, the judge said no. They said, okay, well, how about this? If you're going to allow all of that in, the next thing we'll request is an adjournment of the trial date, meaning we don't have to have trial right now because the Supreme Court had already granted certiorari, which means they were accepting the case on February 28th before the trial started. They were agreeing to hear oral argument on April 25th before the trial started. So you could have waited until they decided, and we asked you to do that, and you said no. In a decision in order that was dated on April 3rd, Judge Merchan ruled, incorrectly in our view, that the motion was untimely, right? So the judge had to find another reason. They said, well, you filed this too late and trial's going to start any minute, and so we have to go and blah, blah. So in an April 15th pre-motion letter, we explained that this law, this 255.20 from New York law, does not apply to motions to preclude evidence. So the judge relied on some technicality to try to stop the motion from moving forward. But it turns out the judge relied on the technicality erroneously. On April 19th, then, Your Honor, Judge Merchan appeared to agree and advise the parties that the court would rule on presidential immunity objections during the trial based on, quote, your arguments in the letters. That's from a transcript. So the judge says, well, it's untimely. And they say, well, no, Judge, you're wrong. It's not untimely. This is a motion to preclude evidence, which is why we filed it this way. So you're wrong. And he said, oh, okay, you're right. I got the rules wrong. So I will listen to your arguments at trial. Now, during the trial, Merchan noted our objection. Your Honor, here it is. Objection to that, noted. And we re-raised the presidential immunity argument. So we've now made this argument multiple times. Now, at trial and during summations, the prosecutors from Bragg's office, they placed highly prejudicial emphasis on official acts evidence. That's all they talked about, including witness testimony. They specifically talked about events in the Oval Office that Bragg's team described as devastating. Right? All of it's official. They also talked about social media posts that came out during Trump's first term. You see these were government exhibits, 407F, 407I. Official acts. You didn't even consider whether he was immune from that or not. We also have the OGE form. That's the Office of Government Ethics form, which came out in March 2018. Who was the president in March 2018? Oh, yeah. And we also have toll records reflecting various calls involving President Trump while he was in office in 2017. All of these are government exhibits. Now, under the Trump case that just came down from the Supreme Court, this official acts evidence should never have been put before the jury. Yeah. And consistent with arguments that we made before and during the trial, the Supreme Court, as we told you, held that President Trump may not be prosecuted for exercising his core constitutional powers. Can't do it. And he's entitled to, at minimum, a presumption of immunity from prosecution for all his official acts. And he was not afforded that analysis or that benefit at all. The Supreme Court says that the presumption applies, quote, unless the government can show that applying the criminal prohibition to the act would pose no dangers of intrusion on the authority and the functions of the executive branch. And that's a high standard, man. No dangers of intrusion, like none. The executive branch is always going to say, oh, if you prosecute us for this, I mean, that's going to intrude upon us. So it's really, really powerful. Bragg cannot make that showing here. Sorry, Bragg. Now, moreover, as we also talked about, Trump also forbids the case from the Supreme Court, the immunity case, which is going to be the Trump case, now known as the Trump case, which is presidential immunity. It's a good case. Says that it forbids the use of evidence about such official conduct, even when an indictment alleges only unofficial conduct. And this includes President Trump's tweets and his public addresses. And so for that type of evidence, the Supreme Court remanded to the trial court for evaluation of whether this alleged conduct is official or unofficial. And we'll address that inquiry with respect to the evidence at issue here. But it's clear now, Your Honor, in New York, Judge Juan Merchan on the 34 felonies for false business records, that, Your Honor, you may not inquire into the president's motives. And you did that, Judge. And you may not deem an action unofficial merely because it allegedly violates some generally applicable law. Can't do that either, Judge, but you did. And so the verdicts in this case violate the presidential immunity doctrine that has now been dictated by the Supreme Court. And it creates grave risks of an executive branch that cannibalizes itself. And after further briefings on these issues, beginning on July 10th, it will be manifest that the trial result cannot stand. Oh, that's good. Yeah, because that's exactly what happened. And we were here saying that, well, first of all, tons of evidence in this trial should have never come in because it was non-credible and not relevant. But the point is, they were introducing stuff all over the place about Trump's presidency. It was official. They didn't do a hearing on this. And this case is not closed. This case is still open. And Trump has not been sentenced yet. So once that document hit, the Bragg prosecutors responded. You can see very short filing. This one came out from Joshua Steinglass. Matthew Colangelo didn't want to write this one. He's still reeling. He's like, what's happening? My whole life is flashing before my eyes right now. Because he's Biden's prosecutor who's saying, wait a minute. I thought I had this all in the bag. This was the closest they've come to getting a felony conviction in their rigged prosecutions. So close they can taste it, man. They're out all over the media saying convicted felon, convicted felon, convicted felon. He hasn't been sentenced yet at all. And now they're agreeing he's not going to be sentenced on the 11th either. Here's what they say from Alvin Bragg's office. On July 2nd, they write back to Honorable Judge Juan Merchan, Honorable, says, all right, dear Judge, we're in receipt of Trump's pre-motion letter, the one that we just read, seeking leave to file a motion to set aside the verdict, to get rid of him, based upon the Supreme Court's decision in the Trump immunity case. They say in that letter, Trump requested until July 10th, one day before the sentencing, to submit a memorandum of law in support of his motion. Now, while Trump's letter states that he, quote, does not object to an adjournment of the July 11th sentencing date, So it's okay if we move that, just delete it off the calendar, reschedule it later, no problem. But while he's saying that, his request to file moving papers, right, his actual motion, his memo, on July 10th is necessarily a request to adjourn the sentencing hearing currently scheduled for the 11th. So he's saying, look, he's saying like, we can file the memo on the 10th and keep sentencing on the 11th, but what the defense is really saying is if you're going to allow him to submit something by the 10th, then the 11th is going to go away. So, okay, so if he wants that, he says, although we believe Trump's arguments to be without merit, that these verdicts are legitimate and they should stand, the government says, well, if they're without merit, then you should oppose it, right? If they're without merit, why would you not oppose it? But we do not oppose his request for leave to file and his putative request to adjourn sentencing pending determination of his motion. Well, if it's without merit, you should probably oppose it. Well, I don't know why you'd want to continue that out, unless it might be with merit. So we respectfully request a deadline of July 24th, even longer than Trump. Trump said, I'll get it to you by the 10th. They're like, how about the 24th? 2 weeks after his requested deadline to file and serve a response. So they want a deadline, all right, 2 weeks after Trump. So Trump could go back out, then they'll have their 2 weeks. I get it. So they'll have their 2 weeks. Trump will have, his 8 days, then they'll have 2 weeks. They need some time to mull this over. So they are now not objecting to this, allowing this to be moved. The sentencing date, they were so close, man. 9 days from today. So close to getting Trump in Rikers Island. Oh, man. And it got moved again. According to the government, they're having to agree to it. Now, guess what happens next? Judge Juan Merchan, presiding over the Trump trial, comes out and agrees the sentencing on July 11th is adjourned. You see, this came out to counsel via email from Judge Juan Merchan in the state of New York, Supreme Court, lowest level court. He says, all right, dear attorneys in the Trump trial in New York, I write to you in response to your recent communications. He says, I refer specifically to Alvin Bragg's email requesting permission to delay the filing of the sentencing recommendation pending further guidance from this court. So as soon as the Trump immunity verdict dropped, prosecutors, we didn't see this in the public filing, they send an email, Your Honor, we don't really know what to do now since the defense was right and since our prosecution was illegal and unconstitutional. We don't know what to do. What would you like us to do? They also say that Mr. Beauvais sent in a pre-motion letter, which we read, which is trying to set aside the verdict because it's illegitimate. And they requested until July 10th to submit a memo of law. The people sent another letter, July 2nd, the day of this recording, requesting a deadline of July 24th to file and serve their response. So if they grant Trump's July 10th, then they want another 2 weeks. So Bragg's office now requests their request regarding the sentencing recommendation was already granted. So they're saying, do we need anything? Do we need to do our homework by July 11th? Because remember, in a sentencing, you have three parties. You've got the judge, you've got the prosecution, and you've got the defense. And both sides are going to prepare a sentencing recommendation to give to the judge. So right now, the prosecution's writing theirs, the defense is writing theirs, but you'll also have a third party, typically called probation or pre-sentencing, or different states call them different things, but they do their own independent analysis. So the defendant goes, meets with them. They do a pre-sentence investigation. There's a pre-sentence report, pre-sentence interviews, all the things. And then this party also gives a recommendation to the judge. So the prosecutor is going to ask for the max. The defense is going to ask for the minimum. And the third party, the independent analysis, so-called, who still works for the government and gets paid by the government, is going to make a recommendation to the judge based on the following interview that they conduct. But now Bragg is saying, we don't know what to do on this. So can we have more time? And the judge has now granted that. He says, all right, so this is granted. And Trump's request to also file their memo, not the sentencing recommendation. So this is a sentencing recommendation. We're not talking about that. We're now talking about a memo on whether or not the case essentially and the verdict should be set aside entirely. So the sentencing recommendation was granted. So the government has more time. Trump's request to file his motion by July 10th is granted. And the response deadline is also granted. So July 24th, which means we're not going to have sentencing there on July 11th. Man, Democrats, so close yet so far away. Trump was going to go into custody on July 11th. Not happening. The sentencing date on July 11th is therefore vacated. Bye. And watch this. The court's decision will be rendered off calendar on September 6th, which just happens to be a great day here. And the matter is adjourned to September 18th, 2024 at 10 a.m. for the imposition of a sentence, if such is still necessary, or other proceedings. Oh, man! See that right there? That little phrase right there? If such is still necessary. And guess what? It's not going to be, because Trump has immunity. And you just admitted a bunch of evidence that should never have been admitted. And Trump told you it shouldn't have been admitted. And you had all the opportunity in the world, Judge Mercan, to allow the matter to play itself out through the courts, through due process of law. But you didn't allow that to happen. And now the Supreme Court corrected the record and you have to comply, and he's not going to be able to do that. So he is now noticing that, man, this sentencing may not be necessary at all. Why would you need a sentencing for a totally illegitimate case? You don't. So very truly yours, Judge Juan Mercan, if such is still necessary. Oh, bummer for them. So the sentencing is gone. We don't even know if there will be another sentencing. The decision this judge is going to render off calendar on September 6th, going to reset a sentencing, and the matter is adjourned to September 10th for whatever happens to come up. Sorry, Judge, totally stinks for them. Alvin Bragg having a bad day today. And we don't know what happened here. What happened with Judge Mercan? Did he watch Biden's debate performance or something? And he's like, oh, crap. Biden told me he was going to take good care of me. And then I watched him come out and debate, and he's like, I don't even know if Biden remembers who I am. I don't know what to do about this. So something's going on, and they now recognize that this is going to be a big problem for them, and they're trying to figure out what to do. Judge Juan Mercan is probably going to wait until he gets some instructions from the White House or Barack Obama. Somebody will give him a call and say, all right, here's the plan. Oh, yeah, that's great. He'll come back out as acting judge and figure out what to do on this. But when they do, they don't want any, this is another thing, they don't want any press there. So this is another filing from Matthew Colangelo. Before the immunity decisions dropped, they had sentencing scheduled, and the press wanted access to this. Okay, so this letter from Colangelo is saying several news organizations wanted audio-visual coverage of this thing when it does go to sentencing. And we don't want that at all. Saying civil rights law bans coverage, and by its terms, it's very easy to understand why cameras are prohibited. And so the people note that although Trump has stated he takes no position on this, this would create a circus-like atmosphere during sentencing. And so we recommend that there are no proceedings. With minor modifications, everything was perfect, and it's your discretion, Your Honor, to conclude no changes are appropriate. And so we don't want any public media in there during the sentencing, which has now been lifted and moved. So they're in big trouble. They don't know what they're doing over there. Even Rachel Maddow is having a meltdown, saying now this immunity decision's out, he's not going to be a convicted felon. We're going to lose everything, and we're all going to die. Here's Maddow. This clip came over from Clandestine, and he posted this one explaining how they sound on MSNBC.
And this is a president who has activated pro-Trump paramilitary groups that, you know, wear insignia and T-shirts and hold placards celebrating literally right-wing death squads, right? This is a president who has talked about absolutely using the Justice Department to go after his rivals. This explicitly immunizes anything the president wants to do through the Justice Department, but all but explicitly justifies anything the president wants to do, full stop, to anyone. And that is as serious as it gets.
Serious as it gets. Rachel Maddow. So they're all under attack now, moving forward. It was a really good day for Trump. You can tell because they're so upset about it. Trump's team sends a letter over to Judge Merchan, and he basically grants it that very important sentencing that they were all scheduling their slumber parties over are now going to have to be canceled. Sorry, Liz Cheney, Nancy Pelosi. Reschedule and have a new date on the calendar. We'll see if it happens. Don't hold your breath. All right, my friends, we're going to continue to cover this trial as it continues. We've got a bunch of new filings obviously coming up. Trump's got a deadline, July 10th. Government will be responding. We'll read through the filings here. Thank you for subscribing wherever it is you're watching this. Thanks for sharing our channel with a friend or family member so that they can join us as this litigation continues to unfold. We'll look forward to seeing you back here and on our next video, which is all about what's happening with Jack Smith and Judge Clarence Thomas in his concurring opinion saying that Jack Smith is illegitimate. So we've got that video coming up right here, and we'll see you over there on the next one. But we're live, so we're not done yet. We're going to carry on, my friends, and jump right into this one. This is going to be some good stuff. We've been following this for quite a while. Jack Smith in danger. The Supreme Court now commenting on his illegality. The reason why he should not even be on this case is because he wasn't properly appointed as special counsel. He was never a U.S. attorney, never confirmed by the Senate, and his appropriations, all the millions that he's gobbled up from the American taxpayer to prosecute Trump, are not his funds, should have never gone to him. And so Judge Clarence Thomas, judge on the United States Supreme Court, wrote a concurring opinion in the Trump immunity case, which wasn't a majority, wasn't part of the holding. So what he says here is not law, but he's giving a very good hint out here to Judge Eileen Cannon in the Florida classified documents case, who currently has this decision on her lap. She needs to decide whether Jack Smith has been lawfully appointed or not, or illegally appropriating funds. So this is what Judge Clarence Thomas has now said in his concurring opinion from the Supreme Court of the United States. Judge Clarence Thomas concurring in the opinion and writing in the case of Trump versus United States. This is the Trump immunity case. Judge Thomas writes saying, all right, America, few things would threaten our constitutional order more than criminally prosecuting a former president for his official acts. But fortunately, the Constitution does not permit us to chart such a dangerous course. As the court forcefully explains here today, the framers deemed an energetic executive essential to the security of liberty, and our system of separated powers accordingly insulates the president for prosecution for his official acts. Now, to conclude otherwise would hamstring the various and vigorous executive that our Constitution envisions, saying while the separation of powers may prevent us from righting every wrong, it does so to ensure that we do not lose liberty. Okay, there are things that may escape some of the rules from time to time, but we don't overcorrect. So Judge Clarence Thomas continues, and he says, you know, I write separately to highlight another way in which this prosecution may violate our constitutional structure, and it pertains to Jack Smith. He says in this case, the Attorney General, Merrick Garland, purported to appoint a private citizen, Jack, as special counsel to prosecute a former president on behalf of the United States. He wasn't a U.S. attorney. He wasn't appointed by the president, confirmed by the Senate at all. Thomas says, the judge, but I am not sure that any office for the special counsel has been established by law. as the Constitution requires. Okay, the Constitution says you fill offices that are established by law. What is the law? Congress. By requiring that Congress, not the executive branch, you don't want the executive to create its own offices. That violates the separation of powers. Too much power in one entity. By requiring Congress to do it, so Congress can make it and fund it, and then the executive branch can run it, the Constitution imposes an important check against the president. He cannot create offices at his pleasure. That would be insane. If there is no law establishing the office of the special counsel that he occupies, he then cannot proceed with this prosecution. Why? Because a private citizen cannot criminally prosecute anyone, let alone a former president. Hello? No former president has faced criminal prosecution for his acts in office in the more than 200 years since the founding of our country until now. Thanks, guys. Now, and that is despite so numerous a number of past presidents taking actions that many would argue constitutes crimes. No, Trump is the first one because he failed to properly label his spreadsheet rows in his TurboTax. That's it. That's the biggest one. Historic, okay? Never happened before. Trump's a monster. Never seen anything like this before. Bad spreadsheet labels. That's the problem. So they break 234 years of precedent because they're maniacs. Now, if this unprecedented prosecution is to proceed, it must be conducted by someone duly authorized to do so by the American people. The lower court should thus answer these essential questions about Jack Smith's appointment before proceeding. Hey, Judge Eileen Cannon in Florida, you listening? Hopefully. The Constitution sets forth, right? This is Judge Clarence Thomas just saying, hey, FYI, this is how this works. The Constitution sets forth how an office may be created and how it may be filled. It's very clear about this. The Appointments Clause provides, it says, the president shall nominate. Did Jack get nominated? No. And with advice and consent of the Senate, shall appoint ambassadors, other public ministers, judges of the Supreme Court, and other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. That's Congress. But the Congress may, by law, vest the appointment of those other officers as they think proper in the president alone, in the courts of law, or in the heads of the department. Okay, so Congress can create these little placeholders and say, we don't need to fill them, but you can fill them. But there's got to be a box for it. Now, the constitutional process for filling an office is plain from this text, pretty easy. The default manner for appointing officers of the United States is clear. Nominate by the president and confirm by the Senate. Clean as clear as day. Now, but the clause provides a limited exception for the appointment of inferior officers. Okay, Congress may, by law, so they write a statute, authorize one of three other actors to appoint inferior officers without the advice of the Senate. So when does that apply? Well, as relevant here, it's when a head of a department like Merrick Garland, the Attorney General, is one such actor that Congress may authorize by law to appoint inferior officers without senatorial confirmation. So you can't appoint an officer if you're the AG under certain circumstances. Now, before the president or a department head can appoint any officer, however, so it's not just a free-for-all, the Constitution requires that the office and the officer who is about to go into that office be established by law. Footnote 1 tells us that although a government official may also be a non-officer employee, I'm going to set aside that category because it's difficult to see how an official exercising, he's saying clearly Jack Smith is an officer. All right, I'm not going to even talk about non-officer employees. Not even going to mention that, says Clarence Thomas, because a non-officer employee would never have the power to enforce criminal law. Only an officer could ever enforce criminal law. That's what Jack Smith is doing. If Jack Smith were a non-officer employee, the constitutional problems with this case would only be more serious. So we're going to forget that. For now, I assume without deciding that the special counsel is an officer. We're just assuming this, because he's prosecuting somebody, and that's the power of an officer. Now, the Constitution itself does create some offices. Most obviously, we have the office of the president. We have the office of the vice president. Now, although the Constitution contemplates that there will be other officers of the United States whose appointments are not herein, it clearly requires those offices are established by law. Congress writes a law and puts them in. And established by law refers to an office that Congress creates by statute. Now, the limitation on the president's power to create his own offices grew out of the founders' experience when they lived in the English monarchy. They were tired of this, all right? The king could wield significant power by both creating and filling offices as he saw fit. I need a new office. Created, funded, filled. He was emphatically and truly styled, quote, the fountain of honor. He not only appointed to all offices, but he could create them too. They talked about this in the Federalist Papers. Now, that ability raised concerns about the king's ability to amass too much power. The king could create a multitude of offices, throw a bunch of his supporters in there, and this became the most insidious and powerful weapon of despotism, which is basically what we have happening now. Thomas Paine talked about it. He says the crown derives its whole consequence merely from being a giver of places and pensions. Just get on that government teat, baby, and you just keep getting fed. And that's why democracy is such a problematic thing. If it's a tyranny of the majority, that serves nobody. It's still a tyranny at the expense of the minority. And you have a top-heavy democracy that then bankrupts itself, as we're in. In fact, one of the grievances raised by the American colonists in declaring their independence was that the king had erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. Sounds familiar. Now, the founders thus drafted the Constitution with, quote, evidently a great inferiority in the power of the president, in this particular to that of the British king. Now, the founders broke from the monarchical model by giving the president the power to fill offices with the Senate approval, but not the power to create offices. Judge Clarence Thomas continues, saying they did so by imposing the constitutional requirement that the new officer positions be established by law, rather than through a king unilaterally creating the offices. Now, the legislature creates the offices. The powers relative to the offices are partly legislative and partly executive. Legislature creates the office, defines the powers, limits its duration, provides it with compensation, and then the power to fill the office comes from the executive. So Congress creates the box, defines how big it is, how long it's going to last, what the box can do, how much money the box makes, and the executive branch fills it. The Constitution thus gives Congress broad authority to establish and organize the executive branch. Now, by keeping the ability to create offices out of the president's hands, the founders ensured that no president could unilaterally create an army of officers and then fill it with his supporters. Instead, our Constitution leaves it into the hands of the people, the elected representatives, to determine whether these new offices should exist at all. Now, long-standing practice from the founding fathers to today comports with this original understanding. Congress must create offices by law. The first Congress did this. Routinely, they created offices by statute. Here, we saw they created the office of the Attorney General, along with the U.S. Attorney for each district. They created the Secretary of War and his chief clerk, the Secretary of Treasury, a comptroller. Still today, Congress creates the offices that the executive branch may fill. Congress has created several offices within the DOJ. They created the AG's office, the Deputy AG's office. They created the Associate AG's office, the Solicitor General, and the Assistant Attorneys General. All of that is clear in U.S. code. But for some agencies, Congress has also granted the agency head the power to appoint officers themselves. And they were clear about this. Congress can create it, or Congress can create it and have the head fill it. But they give that power in the law. So the Department of Ag has it. The Department of Education has it. The Department of Health and Human Services has it. You know who does not have it? The DOJ. In the past, Congress has at times created expressly offices similar to the position that's similar to the special counsel. They created an office for special counsel. That was some time ago. They investigated the Teapot Dome scandal and other prosecutions, and the statute for that created an independent counsel. But that statute lapsed. Congress hasn't reauthorized it, so there is no law there. And so we cannot ignore the importance that the Constitution places on who creates the office. To guard against tyranny, the founders required that a federal office be established by law. All right, James Madison cautioned about this, said if there is any point in which the separation of the legislative and the executive powers ought to be maintained with greater caution, it is that which relates to officers and offices. If Congress has not reached a consensus that a particular office should exist, the executive branch doesn't have the power to create and fill it on its own. So Clarence Thomas continues saying, listen, it is difficult to see how Jack's office has an office established by law. Constitution says he should have it established by statute, and he doesn't. When the Attorney General appointed Jack Smith, he did not identify any statute that clearly creates the office, nor did he rely on a statute granting him the authority to appoint officers as he deems fit, like other agencies have. Instead, the Attorney General cobbled together a bunch of garbage statutes, and he cited 509, 510, 515, and others as justification for this. But none of the statutes cited by Merrick Garland, none of them creates the office of the special counsel, and none of them creates anything with clarity like other past statutes. Sections 509 and 510 are generic provisions about the authorizations and functions of the Attorney General. 515 contemplates an Attorney General who is appointed under the law, saying that, yeah, the office already had to be created. 533 talks about appointing officials, not officers. It's unclear whether an official is an equivalent of an officer, but regardless, this provision would be a curious place for Congress to tuck in the creation of a special counsel. And you also inserted that one into the provisions about the FBI, not the DOJ in the first place. So you're going into other agencies to say you have power to create a special counsel. That's the FBI law. Jack, stop stealing their statutes. To be sure, the court gave passing reference to the cited statutes that supported the special prosecutor in U.S. versus Nixon, but it provided no analysis of those provisions' text at all. And perhaps there is an answer for why these statutes do create an office, but before this consequential prosecution proceeds, we should at least provide a fulsome explanation of why Jack Smith's office is valid. They say, to be sure, Judge Clarence Thomas says, yeah, a few presidents have appointed special prosecutors, and they did that without pointing to any express statutory authorization. But this court had no occasion to review the constitutionality of their authority. So they didn't challenge that, right? Just because they appointed them historically doesn't mean that you can continue to do that. In fact, Congress gave the Attorney General the power to appoint additional officers as he deems necessary, but literally only for the Bureau of Prisons. So 18 U.S. Code 4041 says, yeah, actually the AG can appoint officers, yeah, but only for the Bureau of Prisons. So it's very explicit about that power, and he doesn't have it for the special counsel. Saying that regulations also remain on the books that contemplate an outside special counsel, but I doubt that regulation can create a federal office without the statutory authority to do so. So Clarence Thomas continues saying, even if Jack's office has a valid office, even if he does, questions remain as to whether he filled that office in compliance with the Appointments Clause. So now we have to separate these out. Maybe the box is okay. Maybe the box is fine. But Jack Smith, this person who wants to go inside of it, is not. For example, it must be determined whether Jack Smith is a principal or an inferior officer. If the former, his appointment is invalid because the special counsel was not nominated by the president and confirmed as principal officers must be, so he fails automatically. But even if he's not one of those and he's an inferior officer, the Attorney General could appoint him without the presidential nomination and the Senate confirmation if Congress allowed him to do that. So special counsel's office is invalid unless a statute created that office, created the box, and gave Merrick Garland the power to fill it. So it has to create this box plus Jack Smith and then allow him to insert it into the box. Now, whether the special counsel's office was established by law is not a trifling technicality, okay? If Congress has not reached a consensus that a particular office should exist, the executive lacks the power to unilaterally create it on itself. Now, given that Jack's office purports to wield the power to prosecute, the consequences here are weighty. Our Constitution and our separation of powers, including its separation of powers to create and fill offices, is the absolute central guarantee of a just government and the liberty that it secures for us all. There is no prosecution that can justify imperiling this. And so in this case, Judge Clarence Thomas continues, saying there has been much discussion about ensuring that a president is, quote, not above the law. No one's above the law. Deduct 20 IQ points from any person who says that seriously. But as the court explains, the president's immunity from prosecution for his official acts is the law, always has been the law. No one's actually prosecuted it. It was, in practice, functional immunity until the Democrats decided to breach that. The Constitution provides for an energetic executive because the executive is essential to the security of liberty. Now, respecting the protections that the Constitution provides for the office of presidency secures that liberty. And so in that same vein, the Constitution also secures liberty by separating powers to create and fill offices. And there are serious questions here, whether Merrick Garland has violated that structure by creating a fake special counsel's office that has not been established by law. Those questions must be answered before this prosecution can proceed. We must respect the Constitution's separation of powers in all its forms, else we risk rendering its protection of liberty a parchment guarantee. Meaningless. Signed by Judge Clarence Thomas, making the right point that Jack Smith is illegally appointed, not constitutionally in his position at all. But the Democrats, through Merrick Garland and Joe Biden, continue to say he's legitimate, and the media accepts it. So the prosecution carries on. Now, this will go over to Judge Cannon in Florida, and we'll see what she thinks about this as she renders her decision on this issue and many others. But the point is, the immunity decision touches all of the cases, and this is even MSNBC acknowledging the fact that the J6 is not going to happen before the election, and Trump might win and put the whole thing to bed in the aftermath. Here is MSNBC reporting.
It seems, correct me if I'm wrong, there's no chance that any of these are taken up or go to trial anyway before Election Day.
Absolutely not. And Willie, one of the reasons that it doesn't is because it will take 32 days just before Judge Chutkan even gets the case back. That's because under Supreme Court rules, they have 32 days to issue the judgment back to the lower court unless somebody asks for it. The other thing is Judge Chutkan has to resolve what is in and out of the case before anything can proceed further. And what's in and out of the case has to go through the appeals process again before those pretrial proceedings can continue, because immunity isn't just immunity from liability, it's immunity from the whole thing, right? If you're immune from prosecution, you shouldn't have to go through the process to begin with. So I think there is no chance we see any trial before the election. And the case is going to disappear if Donald Trump is reelected. He will direct the Department of Justice to dismiss the case. He will get rid of the special counsel somehow. We should suffer no illusions that this case continues through the courts if Donald Trump is reelected.
Yeah, because Jack Smith is unlawfully appointed. He's got Clarence Thomas, who's there, also confirming that for us. And so we will keep our eye on what's happening over there. But Trump's attorney also came out and was saying they're going to use this immunity provision as it's intended. It's a broad provision that is going to protect Trump with a strong force field as it's protected other presidents. No other president has had to suffer through this political lawfare because we're going through a new era where communists have taken over and they're trying to ransack our own judiciary and our own justice system. But this victory continues. Trump's attorney saying, we're going to take this and apply it to every case. Alternate electors, Fani Willis, all of them are now fair game. Here is Trump's defense.
Against you on this question of what's official and what's not official. that Trump must stand trial. I mean, do you acknowledge that there is still a chance he does have a trial here for the January 6th election interference case?
Well, first of all, I would note that Justice Barrett's opinion is a concurrence and it's not controlling. I think the majority opinion authored by Chief Justice Roberts very clearly sets out the path ahead. This case is going to be remanded back to the district court. The district court is going to have to determine which of the acts underlying the indictment are immune and which are not immune. And then we'll proceed from there. Obviously, any immunity decision made by the district court, we would have the ability to appeal on an interlocutory basis, again, up to the D.C. Circuit and potentially to the Supreme Court as well. In terms of your core question about the trial timeline, I think at the very least, we're looking at a long road ahead before this case could go to trial, which I think is appropriate given the very serious constitutional issues that this first ever prosecution of a former president presents here.
Yeah, but you have conceded here the last time that you and I spoke in April, and John Sauer, who was arguing this before the Supreme Court, that some of what's alleged would be considered a private act. So that would mean that at least part of this case from Jack Smith would go to court based on what you have said before, right?
Okay, so clarifying this little sneaky question from her, remember Jack Smith's January 6th indictment was filled with a bunch of garbage. It was a speaking indictment where there was like a novel he wrote in there. Most indictments, this person did this thing, this date and time, this location in the jurisdiction of the city. Here's the conduct, the elements of the offense. This person did it. Here you go. That's the indictment signed by the prosecutor sworn. All right, that's it. Jack Smith wrote like one of those magazine articles you see on the checkout lines at the newspaper, the grocery store. I don't even know what it was. It was just a weird kind of rant, a democracy, we're all going to die. It didn't seem like a real indictment, but it was because it was politicized. It was a political prosecution. It was a narrative creation device. And yes, there was a bunch of private conduct in there. There was tons of private conduct in there. But none of that was criminal. In fact, none of the official conduct was criminal either. They're trying to create this narrative, and they're now trying to grasp on to anything like a life raft that will give them enough evidence to create criminality.
We've admitted consistently that there are acts alleged in the indictment that would constitute private conduct, but we believe that if the official conduct, the immune acts in the indictment are stripped away, that Jack Smith doesn't have a case, that this case should be dismissed on that basis. I don't think there's sufficient private conduct here to support the indictment, to support the ongoing prosecution. And that's what we're going to be litigating in front of the district court now.
Even just the false slates of electors, you don't think that would constitute enough for a trial?
No.
Well, we would say alternate slates of electors. And as we argued before the Supreme Court, alternate slates of electors have been a method used by previous presidents, most notably Ulysses S. Grant,
and Nixon,
to ensure the integrity of prior elections. So we believe the assembly of those alternate slates of electors was an official act of the presidency. That's what we argued before the Supreme Court. The Supreme Court has reserved that issue for determination by the district court, and we'll see how arguments fall in front of the district court.
Yeah, we've walked through those historical references here before. None of them compare to what we saw in 2020 with the fake slates of electors. But Will Scharf, great to have your reaction to this. Thank you for joining us tonight.
I would disagree with that, Caitlin, but great to be with you. Thank you.
That does not surprise me at all. Thank you very much, Will.
Well done, Will. Well done. I'm glad he got that in there at the last minute. She was trying to cut him off. You're just a big liar and a loser. No, you're wrong. Your analysis is crap, Caitlin. So well done, Will. On that, Jack Smith is now having to reconsider his entire strategy because he's now been outed as a political prosecutor and a hack who has tried to weaponize our justice system until the Supreme Court came out and brought some clarity to the entire situation, saying immunity clearly applies. And not only that, but Jack Smith is illegitimate. Clarence Thomas confirming that from his perspective, he does not have any authority to do anything that he's done. And so that is a nice hint over to Judge Eileen Cannon in Florida. We'll see if Trump maybe renews this in some of the other courtrooms. And at minimum, when Trump wins the Oval Office, it will be a nice justification legally to say, you get no more money. Where'd your money come from? No more money, illegally appointed. We're going to uphold the law. Jack Smith, you're gone. Goodbye. And those cases can go into the ash heap of history. And so we're going to be here continuing to cover this, my friends. Thank you for joining us as we do. We'll see if this creates new developments in any of the cases we're covering here. We'd love it if you subscribe to our channel wherever it is you're watching this. If you invited a friend or family member over here, that would be amazing so that they could also see what the heck is going on in these cases. We're going to continue to cover them throughout the rest of this election cycle until we get a nice victory in 2024, and we'll be looking forward to seeing you back here on the next one. Next video getting queued up is going to be about Florida, because Trump submitted a reply as he continues to get the motion to dismiss granted in Judge Cannon's courtroom based on the spoliation of evidence destroyed. That segment coming up next, and we'll see you over there and back here on the next one. All right, my friends, one final segment on the day, and then we're going to hear from you. I see some amazing donos have come in. Thank you so much for sending those in. It's a beautiful day. We've got one final segment, and we're sticking with Florida. Government prosecutors destroyed Trump's evidence, and it's important evidence, exculpatory materials that tend to show that Trump is innocent. Now he cannot make those arguments. So what do? We ask for sanctions. What is one of those sanctions? A dismissal of the case. Trump submitted this motion to dismiss and a reply to Jack Smith's response that we'll read through here. And Trump's team went hard on this one. Let me show you what's going on out of Florida. This is a 12-pager, and it comes in the Southern District of Florida. We know this is Judge Alina Habba presiding over this case. Says President Donald Trump, this is Trump writing, now replies in support of a motion to dismiss the classified documents case because Jack Smith destroyed evidence. Trump says, all right, Judge Cannon, this is our final word. President Trump respectfully submits his reply in further support of his motion to dismiss this case based on the spoliation of evidence and in response to Jack Smith's reply. Now, in a blatant attempt to further Jack Smith's election interference mission by rushing to trial without necessary discovery and fact-finding, Jack's illegitimate office claims that this motion can be summarily denied without a hearing. So Trump's team, as we'll hear, has already said that they destroyed evidence. They manipulated the boxes. They didn't preserve the order. They didn't comport with their own procedures. So we can't vet to see whether they did something that was in alignment with the preservation of evidence. There are standards that we have to make sure evidence doesn't get tainted. But they tell us the failed effort by Jack's team to justify that disposition includes mischaracterizing case law, and they're falsely claiming that there are no indicia of bad faith. So Trump's people are saying Jack Smith not only is doing bad things, but they're doing it in bad faith. They're hiding evidence from us. They're lying about what they're doing. They're not being forthcoming. And attorneys have a duty of candor to each other and to the court. Now, the reason that so few cases address analogous fact patterns is that law enforcement rarely diverges. Okay, so Jack's saying, you don't have any other evidence that supports us dismissing this case based on the spoliation of evidence. And they say, yeah, the reason we don't have other case law is because no one has been so terrible at preserving evidence, okay? No law enforcement ever diverges so markedly from the fundamental obligation to preserve the integrity of the details of the search scene. The search scene is central to the investigation, and what you manipulated was stuff that was favorable to the defense. And so when that happened in this case called Soriano, when they wrecked the crime scene, courts find that that behavior is extremely disturbing and it's worthy of harsh sanctions. And that should be the case here. And so for the reasons that we're going to talk about, Judge Cannon, an evidentiary hearing is required here, followed by a dismissal of the superseding indictment because President Trump has made adequate prima facie showing under this case law that shows that this case must be dismissed. Now, prior to that hearing and any other evidentiary hearing, the court should require Jack Smith's office to make further disclosures regarding the handling of the 15 boxes and the office's ongoing discovery non-compliance. They're not giving us materials. They're not giving us evidence at all. So that the defense is not forced to litigate these issues based on an incomplete and constitutionally deficient record. And so we're going to continue on with this. We've got a whole follow-up to this motion coming on. An evidentiary hearing is required. They're going to blast Jack Smith. But remember that this entire case was started through Merrick Garland, and Merrick Garland is somebody that we talk about and we see and learn a lot about thanks to our friends at Ground News. And now, my friends, we're back with the motion in front of Judge Cannon's courtroom. An evidentiary hearing is required, says Donald Trump's defense team. Says there are no stipulated or undisputed facts about the government's unprecedented, unconstitutional raid at Mar-a-Lago. We are talking about the raid. So we have a big disagreement here. We haven't agreed to any facts. We haven't had any undisputed facts as well. But nevertheless, we can agree on much here. Similar to positions the court rejected in following recent hearings, Jack's office demands that the court accept their description of the raid. So Jack says, just trust us. Deny Trump's motion without a hearing. We don't have to develop these facts. We tell you what happened at the raid. That's good enough. Now, the court has already found, with respect to 2 other suppression motions, that the strategic prosecution benefits and purported efficiencies that Jack's office prioritizes over Trump's rights cannot carry the day. There is a factual dispute here. Jack says we did something appropriately. Trump's team says we didn't. We have to get to the bottom of this. Now, in addition, Jack's office also lacks credibility, and we can't trust them. So you can't rely on their testimony. The motion that we filed here was precipitated by untimely disclosures from Jack's office himself. There was exculpatory information that they released only after we looked at the boxes. So Trump's team only got news that evidence was tainted and destroyed after they physically looked at the boxes. Dating back to October, Jack's office stonewalled, and they continue to resist valid defense demands for information and evidence regarding and relating to the raid and the resulting spoliation. The office's current Brady disclosures on these issues, which are also incomplete, and Brady's the material that is exonerative material, they only started disclosing those through vague and flippant language in briefs opposing an adjournment that was entirely warranted. And more generally, the office has also made representations and misrepresentations to you, Judge Cannon, including regarding the pertinent facts, and exhibited a generally disrespectful tone that has led to at least 3 admonishments from the court. Judge Cannon is just blasting them in court. Now, notwithstanding all of this, the office apparently believes that they are in the position to demand that the court resolve factual disputes by taking their word for it. We're not going to do that. And so the opposition brief of Jack's office improperly treats the allegations as established facts that have not been established yet. They seek to excuse their failure to preserve exculpatory evidence by claiming without any support that the items in the boxes necessarily shifted around any time that they were moved. Okay, we can't be responsible for moving the boxes. They always move. Things in boxes move. They rely on over 100 pages of exhibits, including private testimonial interviews of these other people. Person 81, person 34, person 29, and FBI 13. Now, some of these witnesses were a part of the team, either the filter team or part of the raid team. But these people and these issues were not disclosed to the defense team until May of 2024. It was hidden until that time. Now, Judge Cannon, although Jack's office seeks to portray these issues as straightforward and easily understood, they re-interviewed some of these witnesses a second time in May 2024 because they tried to figure out just how problematic the search was. Why would you need to re-interview people if everything was done appropriately? We have a question about what you did. Oh, you did that? Sounds great. Everything was perfect. Thanks for the information. You move on. If you have to come back and ask them again, just want to clarify. You said this happened. Did you do this? Oh, you didn't. Did you try that? No, I didn't do that either. Okay. Well, they're going to ask about this and this and this and this. So let me ask you. So that is the information the office should have fully understood and disclosed originally. The office's Exhibit 11 is a third interview of FBI Agent 13, and it was conducted after Trump filed the spoliation motion. as part of a further attempt to get his or her story straight. So they go back to this person a third time. What'd you do? One more time. So one more time? And maybe they're trying to shove answers in that person's mouth. Are you sure you didn't do this thing? You didn't check that? Are you sure? The exhibits attached to the opposition brief help to illustrate that disputed witnesses' accounts are central to this motion. The defendants are entitled to a vigorous cross-examination of those witnesses because these disclosures have not been made. Now, under these circumstances, they say, Judge Cannon, this is nothing short of irresponsible for Jack's office to urge that no hearing is required based in part on new facts. This is not the first time they've taken that frivolous tack. Now, in addition to ignoring disputes over witnesses, Jack Smith's brief is full of incoherently vague hedging that suggests that they still do not know, this is a good paragraph, or not being forthcoming about, at least, what happened with the evidence that is central to this case. How did they destroy it? According to the office, the FBI, quote, generally, that's their word, generally replaced, quote, handwritten sheets with classified cover sheets. But they offer no explanation as to what generally even means. Why was that caveat even necessary? Generally, so not always. They also said this in their stupid filing. In many but not all instances, the office claims the FBI could determine which document with classification markings corresponded to a particular placeholder sheet. So sometimes they could match the placeholder sheet with the document, but sometimes they couldn't. Oops. But they have not specifically identified the instances when they couldn't. How come? The office claims that the filter team typically alerted the case team if they identified a classified document, but it's not clear what happened in atypical situations. For boxes in the storage room, the office claims that items order within the box was preserved. In the storage room, order was preserved, and contents of the box and were preserved, as well as the contents of the box and the circumstances would permit. Now, we do not know for which boxes and what circumstances that is true. Was that true for all boxes? As the circumstances would permit. That might be a typo. As circumstances would permit. But the office argues that it is not relevant, that the FBI was unable to match the placeholder sheets to the documents. You can't match them. They say this problem did not arise for most of the boxes, but not all. Most of them were good. The basic argument seems to be that the court should not worry about this box, A15, because no charged documents came out of it. Well, nothing came from that, so what do you care? But the evidence of mishandling is relevant to the agent's bad faith, and the scope of the problem remains unclear, even by the terms of their own notes. And so finally, some of the factual assertions here by Jack's office are so facially ridiculous and so unsupported by the facts that the office could only have included them in their brief as part of their PR campaign in the media, including unconstitutional efforts. They're now trying to censor even political speech about their raid. They're trying to mitigate the evidence of the FBI's misconduct. Remember when they wrote in their dumb motion, they said, if it was nigh impossible, they said, to keep the boxes intact during the search, then the experienced prosecutors representing Jack's office in proceedings would never have suggested otherwise. The claim is obviously false, okay? Anyone with the patience and inclination to keep an accurate record of the search at the scene, they could have done that. They could have carefully handled the documents. They could have taken notes about the location. They could have relied on an FBI photographer to take actual photos. That same photographer took other staged photos that were leaked. Why didn't they take actual photos of the orientation of the boxes? Now, the decision to take a contrary course and subsequently rely on false claims of impossibility is itself evidence of bad faith. Now, the special counsel's office mischaracterized the legal basis for this motion. They say, trying to avoid a hearing on this, Jack is mischaracterizing this. Trump is not required to establish bad faith to prevail on this. We have established enough. Our motion is based on two separate arguments. First, any objective member of Jack's team could have understood that you need to have an order of the boxes. If classified documents were buried, that's going to change the analysis. Evidence of the location of the documents, whether they're stored beneath under other materials, would have been potentially useful for Trump. It would support the arguments that the material has not been seen for years if it was at the bottom of the box, and they're trying to show that Trump has knowledge of the transfer of the materials. But now we don't know, because they pulled all the classified documents to the top, allegedly. Now, Jax also misapprehends the materiality of this case law. It's disturbing and contrary to the record for Jack's office to claim that the prosecution was not aware of the exculpatory nature of this. That's ridiculous. Although Jack's team has refused to disclose all of the communications with the filter team, there are documents talking about the location of the classified documents, talking about being commingled. And so these statements were included in their instructions because the DOJ fully understood prior to the raid that the locations mattered. The instructions said, note the location. Why? Location matters. Now, against that record, Jack says, well, it's questionable that we would even be asked about this. And they bring up materiality, saying it's not even material. But it's unclear. We don't know whether it's material. It's completely unclear about how much evidence the FBI failed to preserve. And so we can't assess this until we have a hearing. A few things are clear at this stage. First, photographs of the documents' locations within the boxes could have served as alternative means. They could have taken a picture of the photo of the boxes before they started going through them. Did they do that? No. It does not appear that the FBI took pictures of the intact contents of the box. How dumb can you be? They took all those pictures and they didn't even take pictures of the boxes before they went through them. If you've ever watched a crime scene show, a law show, a murder show in the history of your entire life, you know you take a picture before you start touching things. Everybody knows this. They go up to the box, they just start rummaging through it. They didn't even take a photo of the intact boxes. It's insane. They're corrupt. They did that for a reason. They just wanted to dump them out. Nor does it appear that cross-examination of the search participants will be a constitutionally adequate alternative. We can't just go ask the people who did the search, as it's far from clear that the FBI agents responsible for the destruction of evidence will even testify accurately about the appearance of even the top-level content of the boxes that they rummaged through. Furthermore, this other case does not require Trump or other defendants to waive the Fifth Amendment right to testify about the composition of the boxes that the FBI should have preserved. And for this cannot be resolved just on the papers. We have no alternative. They destroyed the evidence. We can't go anywhere else. Now, Trump has also made a prima facie showing on its face that the spoliation of evidence was committed in bad faith, okay? They did this intentionally. They lied about it. Prior to the search, a senior DOJ official declared, he said, I don't give a damn about the optics of the raid. And Jay Bratt developed an antagonistic with Trump's lawyer. The defense does not concede the government's request to turn off the CCTV cameras was motivated by safety concerns. Why'd they turn off the cameras? Although the Attorney General, quote, personally approved the raid, the failure to document or preserve the orders of the documents was not consistent with their policies. The office also made misrepresentations to you, Judge Cannon. They failed to timely produce evidence related to their notes. They used vague and misleading language in their filings. They proceeded to re-interview some of the problematic witnesses after the spoliation occurred. And collectively, these show clearly that they're acting in bad faith. And so they must make corresponding disclosures for everything now. The court should not tolerate Jack's stubborn refusal to disclose whether the order of the documents is still intact in the 15 boxes that Trump disclosed to NARA. Did they mess those up too? Jack's office takes an all too familiar approach to trying to credit untested claims from another interview, that some of the boxes were consolidated, so they manipulated those boxes. Once again, we are required to call attention to mounting proof that Jack's office thinks that they can restrict their own obligations to disclose Brady material to us. Fundamental fairness requires we get this. The prosecution team alone knows if they maintain the integrity of these boxes. And so at minimum, the office has asymmetric access to the witnesses, and they need to tell us. And now, despite multiple misrepresentations regarding the status of the boxes, Jack's office has said, we take our obligations very seriously, and we've more than satisfied them. But that's not true, Your Honor. Last summer, they told the court that all the discovery was ready from day one. But that's not true. In May of 2024, they gave us more notes from a July meeting that had exculpatory information from FBI agents who conducted the raid. That untimely production was responsive to a discovery demand from us. So Trump's people said, give us more. We want this supplemental. They finally gave it to him. But they rejected that other request at the time. Less than a month later, after they rejected that request, they then said, Your Honor, we've given Trump's defense all of the exculpatory material that we're required to do. Then, in response to a question from the court, the office also suggested, falsely lied to the judge, that the only outstanding material were agent janks consisting of substantive communications. Turns out that's not true. Now, the special counsel's office claims that the notes were supposed to be on a disk. We just made a mistake. The office makes passing reference to a technical problem, but they don't explain it. This, quote, dog ate our homework assertion is dubious at best. And Trump only got this after requesting this material a second time. They told the court falsely that the entire production exceeded our obligations, and that's obviously not true. Now, just last week, Jack's office suggested that they, quote, don't know the answer to a critical question regarding dissent. Stephen D'Antonio was asked about the raid. He has confirmed to Congress that he dissented from raiding Trump. He raised that dissent via email, but Jack has not turned those emails over. The office's answer at the hearing suggested that they have not even reviewed the communications, which they think is part of the prosecution team. Can we have those emails? Well, we haven't even looked at them. Well, how come? Well, we don't know. Ignorance. It's pure hubris for Jack's office to blithely inform the court of their view that they can just give us discovery whenever they want. Now, it appears that they have not actually completed their case file reviews. They haven't even reviewed all the materials. They can only speculate at this point whether they're in compliance with Brady and Giglio, which requires us to give them to give us evidence. So that is unacceptable. And so the continuing nature of discovery does not excuse their untimely production. They have a continuing duty, and they're producing materials after existing deadlines. Now the suggestion that they can comply with their discovery obligations is not true. For the office to make that assertion, they're doing it without regard for the Constitution. Now, the office has steadfastly and wrongly refused to acknowledge that Trump is entitled to evidence of political animus. Their current representations cannot prove to anyone that they've conducted the reviews necessary, much less disclose the data to us. In addition to the professed unawareness of discoverable emails from FBI agents themselves, the office only recently produced a handful of August 2022 emails that do not appear to have been included in their case files. Evidence that agents sent substantive messages about the investigation that they failed to upload to the case file necessitates a more thorough review. We gave you everything. Turns out they didn't give him anything. Now, because of Jack's failures to date, the court should no longer accept blanket representations that all of this is under control. This is ridiculous. At this point, there is too much evidence the opposite is true. Based on the discovery deficiencies that are ongoing and repeated assertions that are against not only settled law, but also the Justice Manual, we urge this court, you, Judge Cannon, to require Jack's office to make a detailed submission about the steps that he's taken to collect and produce the discovery, the steps that are ongoing and have not been completed, and when the office will be able to credibly claim compliance with Brady and Giglio, the disclosure cases with respect to undisputed portions of the team. No evidentiary hearing should take place before these issues are resolved, and the representations will need to be revisited after the scope of the prosecution team is resolved. Signed by a bunch of attorneys we're very familiar with here, Todd Blanche and Christopher Keese, along with Emile Beauvais, Trump's defense attorneys, saying the evidence here was so badly tainted and the comportment of Jack Smith's team has been so lacking in integrity that you can claim that they're acting in bad faith. They're trying to keep exculpatory material that would exonerate Trump from entering into the defense's purview. And so Trump submits this as a final reply, and now it's going to be off to Judge Cannon to see how she rules and how this goes. We're waiting for some good filings and some good rulings there in Florida. Now, an MSNBC lawyer was also out saying that the immunity decision is also very appropriate. So not only is Trump trying to get the Cannon case dismissed on a number of different reasons, this one has to do with the destruction of evidence, but also remember Cannon has some now potential immunity impact based on Judge Clarence Thomas's concurring opinion. And so here is what this gentleman said in response to questions on MSNBC, explaining why immunity is powerful and appropriate.
So, Chuck, I'll start with you. The reaction to this as it came down yesterday ranged somewhere from democracy is dead, we now have kings instead of presidents, to it's a little bit murky. And the murkiness comes in that definition of official acts by a president versus personal acts by a president. Who gets to define that? How you define that? What's your take?
And once again, Willie, I find myself in the rather lonely middle. So I think it is logical that some acts are immune. The core constitutional responsibilities of any president, put Mr. Trump aside, ought to be immune from prosecution.
Makes sense.
Purely private acts ought not be immune. And so the hard part, again, is in the middle, right? What is and what is not an official act? I think we have to avoid the following construction. I don't like Mr. Trump. This opinion is good for Mr. Trump. Therefore, we are on the brink of a constitutional apocalypse. I don't believe that's true. But part of Jack Smith's case is now gone, and he's going to have to fight for the rest. His road to prosecution is longer and bumpier and more narrow. All of those things are true, and I disagree with certain particulars in the case. But in the main, Willie, it makes sense to me that there is immunity in some cases and no immunity in others. And to your point, we have to figure out the rest.
So,
wow, okay, MSNBC brought that guy on. Probably the last time he'll ever be on that channel. But that was good analysis. Just set Donald Trump aside, weird freakos. And remember, this is good for you. It's just like an 8-year-old. Eat your broccoli, okay? Eat your vegetables. It's good for you. You're going to grow up big and strong. Many people on the left, you have to tell them, you want immunity for the executive branch, okay? Everybody who's come before us for all 234 years thought and felt the same way because it's a smart thing to have. Now they're running the opposite direction. But Alina Habba is confirming for us this was a good day for America. Here's why.
Of course, it is a good day when the Supreme Court recognizes constitutional rights of presidents and the executive branch, but we should never have been in this situation to start with. This is a disgrace to America. So yes, the lower courts again will have to hear it. It will, in my opinion, slow down Jack Smith's persecution and selective prosecution of President Trump. And I don't see how this case could go forward before the election. But again, I would say that there's still issues to be discussed, such as how Jack Smith even got into this position, how we allowed our democracy, how we allowed the republic to become one that targets political opponents. The fact that we've been in front of the Supreme Court so many times is frankly a sad day for the American people. It's election interference at its finest. But I'm happy today. I think that Chief Justice Roberts made a good decision for what I'm seeing of. Obviously, I need to read it fully, but recognizing Nixon v. Fitzgerald, upholding that decision and stating that absolute immunity does exist for presidents is a good thing. It's an important thing for all Americans, both Democrat and Republican.
Alina Habba in the house, and she is exactly right about this. It is a good day for America to have presidential immunity to put the speed brakes, the speed bumps in front of the Democrats' weaponized political prosecution, enabled by many Republicans who also just sat on their hands while the Supreme Court had to come in and settle all this. But good news, prosecutors destroyed Trump's evidence. Trump's people now making their case to Judge Cannon, and we're excited to see what Judge Cannon finds, not only on the motion to dismiss on that, but also Jack Smith's appointment and where it goes from here. We will continue to cover the Florida case, the rest of the 2024 litigation, and a bunch more here. So we appreciate you joining us as we do. Thank you so much for subscribing wherever it is you're watching this. Thank you for inviting someone you know or love to come over here and join us so that we can go all through this madness together. We, of course, are going to continue our coverage, but coming up next, we have a great video that is talking about Trump's sentencing and how that got delayed in New York. And so check that one out here, and we'll see you back here on the next one. All right, my friends, that is it for us on the day. We covered 3 good grounds. Trump prosecutors destroyed evidence, and now the case must be dismissed. Jack Smith's in danger. Clarence Thomas saying, "You're illegal, buddy boy." And now Alvin Bragg and Judge Mercan's sentencing has been delayed. Oh, no. So close to finally imprisoning Trump. And now they may not even get any convictions at all because their case was ridiculous. But now, my friends, it's time to hear from you. Of course, we're going to check in with our friends over at watchingthewatchers.locals.com for our members only after party and see what you guys have to say on this one. A very interesting GIF here today from Joe Biden, feeling that nice man's arm as he's looking down and saying, "The hell are you doing to me, Joe?" Good to see you. That one is a fun president. We got this one from Anon Hamster, just became a supporter. Great to see you, Anon Hamster. Patrick H is in the house as another new supporter. We love our new supporters. We do members only streams in the mornings and on Saturdays. We'd love to have you come and join us. Patrick and our friend Anon, we'll see you in the morning. We got this one from Milo Phone Bill, says false. 7122 is another Biden lie. The American Farm Bureau said grocery bill for Cookout is at a record high, surpassing $7 per person for the first time ever. The organization said a 10-person cookout will cost an average of $71, up 5% from last year when the average cost was $67. We got this one from Rick D. What's up, Rick D? Bringing in 10 new membos. Amazing. Laura's coming in. We got Christine M, Stan H, Lady of Quills, Mick B, Judy O, John C, Buddy in the house, Gatekeeper, and Spiral 24/7 Games, all gifted membos courtesy of Rick D in the house. We got Mima is in the house. What's up? Says, I just wanted to tell you that I have another job interview this Thursday. Nice. To work in a private college. That would be great if I had it, because it's exactly what I'm looking for. Isn't it interesting how the universe works like that? Put it out into the ether. What the mind can believe and conceive, the body can achieve. It's a nice little rhyme there, I think from Dan Sullivan. What's going on, Mima? Congratulations. You're the most qualified for the job, and you're the best looking too, so you'll absolutely get it. We're looking forward to it. What's up, Ray Ronk in the house? Gifted 1 membo, EXA is coming in, courtesy of Ray Ronk. We got this one from Sandy saying, this is huge. Sharing a link over to Jeff Clark. What's up, Tony Hay Munkets is bringing in some new membos. 20 new membos from Tony Hay. Thank you, Tony. Look at this one. We got Contrarian Barbarians in the house. Nutter Brudder, Don B, Cat's coming in. Joe V. JG's in the house. Alan P, Becca G, Alien Robot Ghost, Tom F in the house. Anthony Muma, 24/7 Live AZ Skies, Patrick R. We got Roxanne, Ramon F, Janine S, B Torn. What's up, Normie American? Nutter Brudder, David M, Carol M, Disgusted Citizen, and Richard Tatership, gifted membos, courtesy of Tony Hay Munkets. Great to have you. We got this one from our friend Hunter. Hunter, he's here. Membo for 6 months, says right on time. Hopefully great days ahead. Fire in the house. What's up, Hunter? Membo for 6 months, 2/3 of the way to a baby. Great to have you here. Thanks for being a membo. It is. Great days ahead. It's looking good. Hey, what's going on? Barney H., new supporter. Welcome aboard, Barney. We'll see you in the morning for our Membos Only stream. And West Virginia WV Sniper in the house. Membo for 1 month. First month's the hardest. Gets easier from there. Jack Mack is here. Says, I honestly got a little giddy when I heard Clarence Thomas squeeze that bit in about Jack Smith probably not being a legit appointment. Justice Thomas is a man of pure principle and tenacity. What's up, Jack? Was at our event over the weekend. Good to see you again, Jack. Yes, I agree. It was very nice that the Supreme Court finally weighed in on it. We were waiting some time to get some guidance from them. Now it's there. Good to see you, Jack. We got R. Taylor says, I guess I don't understand why SCOTUS couldn't do this a long time ago instead of just letting these Dems go rogue with their tyrannical reign, Rob. What the heck? Yeah, good question, R. Taylor. The answer is nobody brought it up, really. It really hasn't been brought up before. And until the Supreme Court doesn't just go and find stuff and then act unilaterally, they wait for stuff to pop up and then they deal with it when it's in front of them. So it's kind of frustrating, but there's good reason for that. You want stuff to be prepared and matured before it lands on their desk. We got this one from Pinochet. What's up, Pinochet? Over on Rumble says, has there been any indication or explanation as to why Jack Smith was chosen? Is it because of his international criminal court connection? Out of all the Senate-confirmed U.S. attorneys available, Merrick Garland picked none. I think you kind of answered your own question there. I think if it was a Senate-confirmed U.S. attorney, they're probably not going to charge Trump. They'll say, no, this is crazy, man. This is a ridiculous case. Jack Smith is a hatchet man. He's a mercenary. So that's what they're going for. Somebody to just go out there and do a lawfare type assassination. 1R5 over on the Rumbles says, Benjamin Franklin said, he who laughs last laughs best. And he was hardly ever wrong. Benjamin Franklin was a very interesting guy. I listened to his his biography. Very interesting guy. And yeah, it's a good quote from him. Hey, what's up? Nope, hell nope. Just brought in 5 new membos. Scott's Life, Polly Shortcuts, Kumi's coming in, Brian C. and Sarah Gray, all gifted membos, courtesy of Nope, hell nope. Talking about a Biden presidency. Jan C. What's up, Jan K. in the house? Jan K. in the house, gifting us a nice super pair flying through the air. Thank you for that, Jan. Eddie Block, what's up? Eddie Block Films was also there. Eddie Block joined us in Vegas with his real good boy, Donnie. Real beautiful boy. You see in this image right here. Just saying, y'all missed a wonderful time with Rob, his amazing family, and all our friends from the chat. I can't wait for the next one. It was so fun. It was so great. Eddie, it was great, Eddie. We got some great pictures with Eddie and with Donnie. It was a ton of fun, man. And we hope Donnie's feeling a little better over there. His belly was a little, little unwell. But Eddie Block was there, man. It was a ton of fun. Good to see you, Eddie. Thanks for saying that. It was fun. Hey, what's up? Macro Mental in the house over on Rumble says, delicious. Delicious indeed. Hey, what's going on? Pookie's Ma says, Rob, this Florida girl is super jealous about missing this weekend's festivities. I have a few questions. What was the head count for the meet and greet? It was about 68, I think we counted at one time, which I would imagine we had people come and go, so it was probably in the 70s. We had people come say hi for 20 minutes and go off to other places because they were just in the area. So it was, I don't know, probably over 70 total. It was crazy. We were expecting like 50. Are you going to consider an East Coast meetup? Yes. And if anybody knows how to get us into Mar-a-Lago, that would be awesome to figure out how to do that. And I'm only half joking. And in this morning's show, Tapper or his guest said Trump's number of interview or conferences is comparable to Joe's. In my mind, that's insane. I remember Trump leading press conferences for hours each day during COVID. Is that fake news or am I misremembering? Yeah, it's absolutely fake news. I think that they're counting every time like he walks by the press and screams at him on the way to the helicopter. They're saying like that's a press conference. So their numbers are just fake. Obviously, they're just fake. So, yeah, it's funny. Anyways, great to see you. Yeah, considering an East Coast meetup, if we can't get into Mar-a-Lago, maybe Trump Miami or some other place. There were some great suggestions over this morning stream about where to go. Maybe Tennessee, maybe Myrtle Beach, South Carolina, some other places. But we'll see. It was a ton of fun, man. I had a ton of fun. It was a lot of work. I learned a lot. and I learned some things I can improve upon for sure. And we got some great feedback. Kay Bean sent some feedback. Zach Nichols sent some feedback. So we're thinking about, a future of these. What does it look like? So still processing a lot. It's going to take me like a week to process it all, but it's going to be fun. What's up? This one from Alice Elizabeth says, hey, just wanted to fill you in on what Seymour Hersh is saying on Substack. He's painting a horrifying picture of the White House keeping Biden as basically a prisoner, keeping him isolated, only bringing him out to say his lines. It's classic elder abuse. I think it needs to get out. It's so awful. So I subscribed to his Substack. I read a little bit of that. And I've seen other stories that Hunter Biden is apparently now running the country. So maybe he always has been. What's up? Rob White says, fruit of the poisonous tree. Indeed, dismiss everything. Sheila P says, love your excitement with application of the new SCOTUS ruling. Keep up the awesome work, Rob. We love you here. I love you, Sheila. Thanks for saying that. I love you back. You're always super supportive. Thanks for being here, being a great membo. Yeah, I do get excited. I am excited about this ruling. It makes sense. I kind of wish the ruling would have been a little bit hard, I don't know that the district courts are the best body to make these decisions, but okay, I can understand it. Maybe they'll tighten it up over the years, but good to see you, Sheila. Thanks for that. B-Man says, if Mr. Biden doesn't pardon himself and his son before he hopefully leaves office, the incoming President Trump can prosecute. And he should. Yeah, he should. Because Joe Biden conducted a conspiracy to deprive us all of our rights to attack his political opponent, and he used the entire federal government to do it. So there should be major prosecutions. And that's just the law. No one's above the law. This is America. Lammy J says, could Trump seek damages and costs on case dismissed because of the Supreme Court ruling? How many millions of dollars are wasted? Yeah, generally not. I mean, you can be acquitted in your criminal trial. You're not getting a dime back unless there was some other. They have qualified immunity. They can investigate crimes. You get caught up in it. Unless there was some other violation of your civil liberties or something, it's just you had a bad go. Yeah, that's our government. Presumption of innocence. Land of the free. Hey, what's up? Betrayed by corrupt scumbags says, karma is a dish best served cold. Indeed. This one from Richard C. became a new supporter. Great to see you, Richard. We'll see you in the morning on our members only stream. Hey, Jennifer says, another great show, Rob. Oh, and a great news channel on YouTube is called S2 Underground Fight in the Shade. That sounds pretty cool. Reminds me of that scene from 300 where he says, our arrows will blot out the sun. And he says, well, then we'll fight in the shade. Great line. Great movie. Hey, what's up, Jennifer? Sounds like a good one. S2 Underground. Hey, this one from Knox Bierman says, happy Taco Tuesday, all. A private citizen. Quote, love that. You rock, Justice Thomas. Yeah, he did. Why is a private citizen just charging Trump? Very curious. Hey, Knox says, I would have loved, some asshat off the street a little bit more, though. A private citizen is about as close as we can get to some asshat off the street. Couldn't actually put that in the opinion, but we know what he meant there, Knox. Good to see you. Rick D says, Justice Jackson cited Hopkins and Clemson in her dissent. How does a land use probate case in the Supreme Court for land use relate to the executive powers of the presidency? Well, I don't know. I'm not a legalologist, so I don't know what Judge Jackson was saying. I'm just a lawyer. I'm not a legalologist. I'm sure Judge Jackson's not a legalologist either. And so I don't know. She's probably getting confusion about biology, legology, Russianology, who knows. What's up? To be clear to you says, get this PDF called The World Teacher for All Humanity by Benjamin Krim that has a bunch of AKAs. Not a religious figure or a book. It's about geopolitics. It's easy to find, and it's a free PDF if you're interested in checking that out. Don't know what's in it, but it's available if you want it. What's up? Charlotte is a new supporter. Welcome aboard, Charlotte. Good to see you. Thanks for joining us as our newest supporter. We got this one that just came in from Troublemaker Davey. What's up? Says, just wanted to say hi to all of the amazing people here. Keep up the great work, Rob. Hi back to you, Troublemaker Davey. Thanks for saying hello to everybody. And thanks for sending in a dono today. We got Queen Bee's Art Hive. Hey, 8 months as a member. One more month till we have that new baby. Says, love you, Rob, and the watchers. Hearts and winky kissy face. Y'all rock. Y'all rock back your way, Queen Bee's Art Hive. Thanks for saying that. Thanks for being a membo for 8 months. One more month. Sheila P. What's up, Sheila? 10 new membos coming in. Amazing. Sheila, super generous today. Says, Cougar Tracks is here. Bob D. We got Linda D. What's up, TPJ? Cyprian Cole, Carol M. Rial in the house. Strawberries here. Shadow Wings and Joan Kelly. All gifted membos, courtesy of our friend Sheila P. Bringing in newest of membos. Hey, Bob Dabalina. Been a membo for 2 months. Talking about Big Mike with an eggplant. 2 months as a membo, gets easier from there. What's up, Michael Lee, is another supporter on the tubes. Thanks for becoming a membo, Michael. We'll see you in the morning on the membo stream. Hey, what's up, Roy MC? Says, were there any issues in the Carroll case that could come under the immunity decision? So I think the defamation part of that case could, yeah. Remember, that was about actually DJ Diddles, grab him by the purse type of situation. Error, you know? Like a DJ in a Bergdorf's dressing room, which never happened. So they said that that happened like 1993, whatever that was, 94. So that obviously not. There's nothing in there that would ever be an official act. But Trump commenting on a false claim lobbed against him, I would say that's clearly an official act. Like the president has an obligation to preserve the sanctity of the office. If some hack out there is saying, you attacked me, the president can say, no, I did not. Stop trying to diminish the office of the presidency. He can respond to that. I would say that's an official act. He's entitled to immunity on that. So the defamation, so that judgment should be reconsidered in light of that. What's up, Waldo? Bringing in 5 new membos. Thank you, Waldo. Eureka H is coming in. Andrew S. War Mode Engage. We got Lydia H. and Savage Cashew all in the house. Thank you, Waldo, for being a membo and bringing in our new membos. Nitty Linny says, poor Jack, if he had come after Trump for violating the Farm Bill through the DOA, he could have been a real boy. Maybe he'd argue that the Mar-a-Lago grass was too green or something. Yeah, he could have through the Department of Agriculture. Trump's overwatering his lawn. You're going to jail for that. Funny comment, Nitty Linny. Jack Smith. Yeah, Clarence Thomas just confirmed he's not a real boy. But I want to be a real boy. You're not, Jack. Get out. Glocky says, like I said this morning, blue states are now swing states, and someone leaked internal polls for the DNC, and it's a disaster of historic proportions. Check out Citizen Free Press on this. Whoo, looking good. Rick D says, you know, Jackson also cited Olmstead versus United States from 1928, involved in the illegal importation of liquor from Canada during Prohibition. Neither case, Hopkins nor Olmstead, involves the president. It sounds like she was a judge in search of a case. She was trying to find any case that she could just tease out some good language. Good to see you, Rick. Thanks for doing the digging on that. Glocky says, internal Democrat polling now shows Trump beating whoever the Democrats replace Biden with. In fact, Biden is still the strongest candidate against Trump. It's about to get wild at the DNC. Pinochet's helicopter tour says in Minnesota a week ago, 5 people were indicted for trying to bribe a juror in a left-wing case, $250 million COVID fraud scheme. What proof do we have that Trump's New York jurors weren't recruited or curated? None. None at all, other than the process. That's all we got. ELF, what's up, ELF? Bringing in 10 new membos. Thanks for doing this. North Star's coming in. Riley Small. We got 40 Railmen. Bia Reeves, Michael K, Virginia H, Renee M, Tracy C, Porsaw J, Lao Su is here. All gifted membos, courtesy of ELF in the house. We got this one from Lenny Malley. Says, hey, thank you for liking the like button. Thank you for smashing that like button. Thank you, Lenny, for the nice reminder. Milo says, Massachusetts throws out 21,000 drug conviction after a state chemist tampers with evidence. So what happens to Jack Smith after his evidence tampering? Isn't that crazy? 21,000 drug convictions. Serve and protect out there. Nice job, chemist. Well done. All right, he should serve the time for every one of those people. Corrections 101 is our newest supporters. Welcome aboard, Corrections 101. We'll see you in the morning. And Don Goff brought in 5 new membos. Thank you, Don. And thanks for sending them in. And you know who you are. Don brought in 5 people. 1, 2, 3, 4, 5. You know who you are. Thanks for bringing them in. What's up? Knox says, hey, chain of custody, as we have previously discussed, is huge for a trial lawyer all day. And these are FBI agents, allegedly the creme de la creme. If HPD understands chain of custody, the FBI totally knows how to properly gather evidence. Probably talking about Houston police, maybe? Because Knox is a defense attorney in Texas. Yeah, and that is exactly right. I think they intentionally wreck the evidence. Trump's lawyers caught it. Tony Hay says it's kind of sad if Trump wins from the Supreme Court decision. They'll still call him a criminal, even though he did nothing wrong. Yeah, they will. They'll say, well, he was still convicted by a jury. He just got off on a technicality. They'll clearly will continue to say that. Rick says, how is Jack's office refusing not a violation of United States versus Bolt? Great question. Not familiar with the case that you're referencing right now, but it sounds like it might be a violation based on your question. Thanks, Rick. What's up from Rick? Bringing in 5 more membos. Thank you, Rick. Timothy Crystal coming in. We got Kimmy Weiss Censored. We got Vaughn Miller Crossing. We got Pan-Seared Ribeyes here. And Curtis C. Gifted membos, courtesy of Rick D. Bringing in new membos. Hey, Jennifer says, hey, as soon as you're done with this show, head on over to Off Label Podcast because it's going to be a great show. And Jennifer says, please show Off Label Podcast some love after Rob's show tonight, fam. Go on over there. It's going to be a great stream. I'm sure Voice of the People will be there. Jennifer, are you going to be there? It's going to be great. Amazing. Check it out. What's up? Rocky Water says, a sweet, sweet news day. Thanks as always, Rob. And it was an honor to meet. Yeah, it was. Rocky Water was there. It was a ton of fun. Now I can act all cool when I tell my future grandkids, yeah, I hung out with Justice Govea once, way before he was world famous. Justice Govea. It'd be great, man. I think if I become a Supreme Court justice, I think my first order of business will be to bring back the wigs. Big ones. Mandatory as Chief Justice for everybody, especially Judge Kagan. Just cover it up all as much as we can. All right, Rocky Water, thanks for that. Hey, Gary Van Horn sent in a new super chat. Your first one ever on a live stream, Gary? Man, we're very glad to be your first here. Thanks for doing it with us. Gary Van Horn, #1 fan, first super chat on a live stream. We're happy to be your first, Gary. Thanks for that. What's up? James Fifth is now a monthly supporter over on the Rumbles. Great to see you, James. Thanks for supporting us over there, my friend. Really appreciate it. And Chubby says, I feel sorry for Judge Cannon, okay? She has to read so much about this and repeatedly reviews Jack Smith's taint constantly. Taint every day in the filings. Not a task I would like to undertake. Yeah, I was going to say taint a task you'd like to undertake, you know? Get it? All right, thanks, Chubby. Hey, Tony Hay Munkett says, want a real win. One that makes the media have to shut up and admit the truth and their lies. I'm sick of this. I want them to admit the lies, and I want them to repent. From Tony Hay Munkets. Hey, this one came in over from the Rubos. You know where to find them at rubosaltshop.com. Here's a link they shared from Trump. It says, total exoneration. It is clear that the Supreme Court's brilliantly written and historic decision ends all of crooked Joe Biden's witch hunts against me, including the White House and the DOJ-inspired civil hoaxes in New York. All of these unfair charges represent the worst level of election interference ever seen in our country's long and storied history. It must be understood that I was totally and completely innocent from the beginning of this giant and highly illegal scam long before the Supreme Court's decision was released. The impact of the immunity ruling is loud and a clear signal for justice in the United States. I am proud to be an American. From Donald Trump. Yeah, we'll see. I think there's a good argument for that. And even the E. Jean Carroll case, I think, is appropriate. We'll start to see new filings on a lot of this stuff. I'm excited. What's up? This one from Roy MC says, the appointment of Jack Smith was by design. Even if he fails, he just disappears back into oblivion without any loss. Just a hatchet man. Sheila P. with 20 new membos. Oh my gosh, Sheila, thank you for sending these new membos in. we'll see a bunch of new people in the morning. SJ's here. Lisa E. Stabby McStabwood is here. We got just another Oglesby. James T. What's up, Christopher? AB is coming in. Gundam is here. Swamp Saga City. 2 Tim 3. Summer Sunrise. Tony R. Sean E. Jason A. We got Chief Vince. Lala Jean, I think, got 2 membos. I don't know what happened there. But Laura got 1. And Dan and all gifted membos, courtesy of Sheila P. Thank you, Sheila, for bringing in so many new membos today. You're the best. We got Acid Burn. Says, God save the king of presidents, Trump, from Acid Burn in the House. Rick D says, do you think SCOTUS intentionally did not release the immunity decision until after the 1512C decision because of both aspects of the DCJ6 Trump case? I think there was probably some strategery to that, to use a George Bush term, in how they released it. I think they also had oral arguments like last. So it might have just been that. They might have just released the last oral argument at the last day. But you might say they held it until after the debate, or they were going to get it out before sentencing either way. But maybe, I don't know that it really mattered either, which one came first, but that would be, I think, reasonable to think that they timed it. What's up? Jaffrey Adams says, Doral to meet, that's Trump's property, meet at Doral for another Trump meetup. We'll see. We got Cowboy Rob, what's up, says, what do you think would have happened if Trump had just decided, Jack Smith is illegitimate, we're not going to participate, prove you're legitimate first? They would have issued an arrest warrant. He would have gone to the courts. Like, in other words, if Trump didn't show up, they'd say, well, it's a failure to appear. That's an arrest warrant for not coming to court. We got this one from Trevor H. Welcome aboard, our newest supporter, Trevor Hammer in the house. We got Tony Hay Munkets is bringing in even more membos. Thank you, Tony. 5 membos coming in. Janet L. Chanel D. We got Libby T. Theodore S. and Holo SD gifted membos, courtesy of Tony Hay Munkets. Thank you, Tony Hay. This one from Nitty Linny is here. Says, next meetup at Opryland Hotel in Nashville, Tennessee, and I'll be there. It's just down the road. Well, that sounds very convenient for you, Nitty Linny. It would be very convenient. I was just there. Went to the Bass Pro Shop Pyramid. Opryland. I've never heard of it. Sounds great. I'd like to go visit Tennessee and check it out. Dolphin Fan is the man is here. What's up, Dolphin Fan? We got so many membos. Dolphin Fan, look at this. Bringing in 10 more. George Orwell, 2020's coming in. Death Devastation. We got Kimberly W, Chalky81, Ed W, Glowin C, Clinton W, CD117, CM Books, and Mary H. Gifted membos, courtesy of Dolphin Fan is the man in the house, bringing in 10 new membos. Thank you, Dolphin. Chief Vince is here, bringing in 5 more. So many membos. Ryan H, John L, Doc B, what's her name is here, and Bernard L, gifted membos. Tomorrow's membos only stream is going to be lit. Hey, JC says, welcome to Kami Zulu. Diversity of thought rocks. Welcome to Kami Zulu. And speaking of Zulu, we have Zulu here, who's bringing in 10 membos. Thank you, Zulu, for bringing in 10 new membos and modding down the fort for us. Bringing in Brenda J, Mary S, K Burkhart. We got Samantha H, Lesko Gadsden, Mary Ricketts. We got the Quacksmacker here. Mister's here, Jack Danielson, Andy K, all gifted membos, courtesy of our friend Zulu. Modding down the fort for us, bringing in new membos. MAGA Hat Stays says, can tweets from the E. Jean Carroll trial get thrown out? Yeah, so I think that's right. So any of the other evidence from Trump that he said that was official act business, I think would also be precluded. So when I'm thinking about like the evidence that they used, I think the trial should be, the verdict should also be thrown out and he should have a new trial on it. But because he also made immunity arguments, I think, during that trial too. He already etched that in. So now that that's over, do like a post-conviction relief, even though that's a civil case, type of a mechanism to reopen the case. set aside the verdict and the judgment because they brought in official stuff to show his intent, to show that he was guilty. He was defending himself. Those were all official acts. He was defending himself by speaking out about this. Those are all official acts. You can't use that. So if you use the official acts in order to get people to think that he did the thing 20 years ago, then all that should be precluded too. So I think it should also get that case thrown out. Ken Ross, what's up? New supporter in the house. Welcome aboard. We'll see you tomorrow on a members only stream. Rub some dirt on it. Says, here's just a thought. But might Justice Jackson have used Google Bard like constitutional scholar Michael Cohen suggested? Maybe she did that. You'd hope that a Supreme Court judge wouldn't be using Google Bard. But Michael Cohen did. And as we know, many people on the left love him. He's like the smartest person that they know. What's up, Just Me says, I hope Judge Cannon slips in, quote, if you wouldn't have fought the special master I tried to get you to use, yours wouldn't be neck deep in this evidence tampering problem somewhere in her decision. Saying, well, yeah, maybe the boxes would have been in order if you would have just let someone competent handle the boxes. But the special master then would have seen their corruption and expose them. So that's the last thing that they wanted. But you're right. She could say, I tried to help you. I tried to help you. Good to see you there. Just Me. Thanks for that one. This one came in from William Capps as a new supporter on the YouTubes. We'll see you tomorrow, William, on our members only stream in the morning. It's going to be great. The Rubos are in the house. Man, they're sharing this one. Free political prisoner 50635-509, Steve Bannon. And I'm keeping my eye on the Steve Bannon stuff. He's saying, don't write him letters, just get to work. So that's what we're doing, Steve. We're getting to work here. We'll see you in 4 months, and we're going to be much stronger and ready for your return when you're ready and out. Knox says, we should do an election night watch party in Arizona somewhere. I mean, there are no peeps I would rather watch with my fellow watchers. That's an interesting idea, too. An election night watch party, maybe with a live stream on it that we multitask on. I like it, Knox. I've got so many ideas in my head. I can't even wait to share it with you guys. What's up, Cowboy Rob? Says, immunity for election interference. I doubt it, says Cowboy Rob. And Pookie's Ma says, can we request a full show in the Pinocchio voice? That was amazing. Is that the real boy one? I'm a real boy. Yeah. Like Jack Smith. Yeah. What's up? Libby T. Love your show. Libby T. Hey, thank you, Libby. I love you back. Thanks for being a membo, supporting us. Couldn't do this work without you. So thank you so much for being here, for sending in a dono and supporting us on the day. John McGarvey says, Election Day Fraud Watch Party. Yeah, we did an election live stream last year. Remember that? It was quite a long one. And we went to bed. It was late at night. And the sun's coming down and beaming in my face, as you can see. But we like those windows open, so we'll just deal with it for a minute. All right, let's see who's on X joining us over on the X tubes so we can say what's up. Hey, Drunk Pinata's in the house. What's up, Drunk Pinata? Says, I wonder why this timeline was not highlighted during the trial and gives us a detailed timeline, which I'll refer you to over on our X post. Thanks for that, Drunk Pinata. Danny McWilliams is over there. What's up, James Pepper? And Irene A. What's up, Space Cowboy? Irene A. and Space Cowboy says, didn't SCOTUS just reiterate what was already done? What was already the law on immunity? What's the media fuss? I don't get it. Terrific analysis. Thank you, Space Cowboy. What's up, Pix? We got George's in the house. One more heading you're missing on YouTube is the heading of election interference, unless I'm missing it. Love watching the watchers. Thank you for that, George, for being over there. Christian Fellowship Rob is also in the house. Azok is in the house. Says, watching all the red lines reminds me of my English essays. With dyslexia, always got the red lines. Mark them up, baby. Mark them up. Troublemaker Jonah and Caspa Sean are also in the house. Great to see everybody over on X. And so you can follow us over there. You can also watch us over there on X in case you're looking for another platform to follow us on. That is where you can do it. But my friends, that is where we're going to leave it on the day. We are going over to watchingthewatchers.locals.com for our members only after party. We got this from Bruce Wayne in the house. Says more than 30,000 statutes that Trump can use as official acts. And Jack has a long road to hoe. That is true. Absolutely true. Going to have a tough row out there. Tough row to hoe. And that's his own fault. Maybe he should have charged actual crimes and not been such a prosecutorial hack. Life would have been better for him. But all right, my friends, we are going over to watchingthewatchers.locals.com. We're going to debrief with our locals friends and our members only after party. So come hang out with us. We still got some stuff to talk about. And we also have our website, robertgovea.com, and our lodge, which is at watcherlodge.com. And so you can check out those different places to find some of the other stuff that we're doing. But before we wrap it up, we want to say thank you to our mods and our meme smiths who are all modding down the fort for us, keeping things nice and orderly. We've got K-Bean in the house, Just Cause, Playing Hooky, Ronnie Cole, our friend Zach Nichols, Janek, Dog Digger, Economy Pilot, Donut Mind Me, Carrie B, our friend Zulu, and our meme smiths, Sleepy Dog Lee, Nathan, N810, Geegum Geegum, Glocky McGlock, and Elliot, our Doc Master, all keeping this train on the tracks. And we're grateful for everybody who helps make this thing work. We're grateful for you. But my friends, that is going to be it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. And if we don't see you over there, no problem at all. Tomorrow's going to be Wednesday. It's going to be hump day, middle of the week. And we're going to have a lot of business to get into. And in order to do that, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.